Good afternoon, everyone, and welcome. Thank you so much for taking the time to join us. I'm very excited about the session today. It's one that I particularly enjoyed. My name is Nobuko Sintombifuti Zulu, and I work at ISLA as the Knowledge Production and Capacity Strengthening Manager, and I'm very excited to have you here today. I'm just going to give another 2 or 3 minutes for other people to just jump on, and then we will just jump straight into it. Thanks. Okay, we're just going to start, and hopefully everybody else will find us when we are already in there. I'm sure they'll join us in a minute now. I'm very excited to have those of you who joined us punctually. Thank you so much for being here and not necessarily holding fast to African time. Thank you for that. So today we are launching a very exciting publication, one that is very near and dear to my heart, that ISLA and her partners worked with over a period of time, and that is a publication that focuses on litigating for reproductive justice under Article 14 of the Maputo Protocol. And this is a manual that is designed to be able to assist civil society, practitioner, government officials, and the whole host of people in actually understanding this incredible piece of legislation, and as well as how to engage with it and its many different subsections, how to actually bring about the realization and protection of women's rights, women's sexual and reproductive health rights. And we have an amazing panel here with us today. I'm just going to give them a minute just now to introduce themselves, but they are experts in the field, and they're going to be leading us in this conversation, and you are in for a treat because these people know what they're talking about. And if you haven't yet accessed our ebook on the publication, if you check in our chat box, you'll be able to access it and read it after our session. And you can also follow us on all our social media pages to be able to gain access and see what's going on. So without further ado, I'm going to introduce our amazing panel. And I will start with Lesego, who will introduce herself and her areas of incredible strength. Lesego, over to you.
Thank you so much, Nobu. Good afternoon, everyone. Good morning to everybody that's joining us from the morning side of the world. My name is Lesego Nchunga. I'm the Women's Socioeconomic Rights Lawyer at ISLA, and I'm also a candidate at the Center for Human Rights, studying for my master's in sexual and reproductive rights in Africa. And I'm quite excited to engage with everyone this afternoon. Thank you.
Thank you, Lesego. We are excited to hear what you have to say. Gladys, please go ahead.
Good afternoon, everyone. My name is Gladys Mirugi Mukundi. I'm a researcher at the Dola Oma Institute. I focus on socioeconomic rights. That's about me. Thank you.
Thank you, Gladys. Nerima, please go ahead.
Thank you, Nobu, and good afternoon, morning, day, everyone. I hope you're all doing well. My name is Nerima Were. I work with the Kenyan Legal and Ethical Issues Network on HIV and AIDS in Kenya. I'm the Deputy Executive Director here, and I am an advocate, litigator, and a feminist. Thank you so much for including me in this.
Oh, thank you. We're so excited to have you. And Nerima, we're just gonna jump straight into it. And my first question is for you, Nerima. And Kellen is a dear partner of the work that is done at ISLA, and there's so many collaborations that have come about. So I know that there's a lot of areas of expertise around this type of work. And so my question for you to get us kicking, Nerima, is, Kellen does a lot of work litigating around sexual and reproductive health rights. What was new in this manual about the trajectory of sexual and reproductive health rights that you saw?
Okay, so, well, I would like to start by congratulating ISLA on this manual. I think it's such a useful resource. And while Kellen has worked for a number of years on litigating human rights, health rights, the rights of marginalized people, and Srhr, what I did pick out from this that was different from other publications in terms of capturing and then also guiding was that it's very intentional in who its audience is. And in its intentionality, it's very clear in its guiding steps. So for one thing is that the inclusion of jurisprudence throughout the manual. In many manuals, you will have an inclusion of jurisprudence, and mostly you have compendium of cases. When you're looking at litigating human rights, socioeconomic rights, you'll see compendium of cases to see X amount of cases under this right, X amount of cases is what the case has said. But what this manual did differently was that it actually spoke about the scope of the right and then started to see how this had been interpreted through the courts throughout the years, and then how then it will give you a normative understanding of the scope of that right. That's the first thing. The next thing that I found that was very important about it was it kind of looks into the judicial interpretation of things. So it wasn't enough to just say what the right says and what the scope of thing is. It also got to a bit of a negotiation, and like if you're arguing and they use the word and can be disjunctive or conjunctive, how would you be able to argue for this and in your case? So it kind of gives you a sense as a litigator, as I'm reading through this, where can I pick out my arguments and how can I utilize them? And then finally, what I found interesting about it was that it was able to link both the Maputo Protocol in the sense that with Article 14 and the normative content there, but then linking it to other treaties and also national jurisprudence. So looking at CEDAW and how CEDAW has looked at things, looking at ISASCA, CEDAW, the Committee for Elimination of Discrimination Against Women, looking at the committee with ISASCA, the International Covenant on Economic, Social, and Cultural Rights, as well as also looking at national courts and how they've grappled with some of these questions. So what was new is that it started from the framework of what are the rights and not really what are the courts saying, and then use the courts to now bolster our understanding of those rights. And I don't think I have seen anything of this nature in terms of a manual. So from a litigator's perspective, you have a sense of, okay, this is my starting point, this is how I would go, and then this is how I'd be able to do it. And then finally, it has tips throughout the manual, as well as even speech bubbles saying, this could be a cause of action. You can frame your arguments like this. So there might be aspects that we don't know that the rights can be looked at like this, or we don't know potential issues that can arise from these rights until you have a manual that shows you, and then you might just find, oh, I have a set of facts that can fit into these cause of actions, and without the manual, you might not have been able to draw those linkages.
Thank you, Nerima. I absolutely agree. I think that one of the key things that stuck out to me in the manual is how practical it is, right? It is so useful. It's not one of those, people produce so many pieces of work around, sexual and reproductive health rights, and all of it can seem so academic. But what was beautiful about this manual is it's so practical, it is applicable. It's not the type of thing that you will download or print and put on a shelf somewhere. If you are a litigator and you really want to work in these types of issues, you're going to keep referring. And like you said, the speech bubbles were absolutely amazing. And it's such a good piece of material that can really impact and empower litigators across the continent. And so to that end, Lesego, I want to ask you, what are some of the emerging issues and trends on sexual and reproductive health rights violations that can actually be addressed by litigating under Article 14?
Thank you, Nobu. I think to start off with, we have to have a conversation about how sexual health technology is quite a novel field on its own. So sexual health technology, as well as assisted reproductive technology, right? And I think that Article 14, particularly 14.1a and 1c, they can be used to intervene in cases in that sense. So the first emerging issue that I'll talk about is on controlling one's fertility, and specifically voluntary regulation of fertility. So oftentimes when we speak about this, we speak of a person who is able to conceive from the time that they're able to conceive, carry to term, and deliver a healthy baby. And there are violations that some women encounter in that. And one of these violations that comes out also in this in the manual is on forced, coerced sterilization. And I think forced or coerced sterilization was addressed by the Namibian Supreme Court in a matter where 3 HIV positive women had been forcefully sterilized in a public health facility, right? And the Namibian Supreme Court, upholding the decision of the High Court, decided that the women, were to be compensated for the harm that they had suffered as a result of forced or coerced sterilization. Of course, a criticism about that case is that, the court failed to recognize the intersectionality in discrimination suffered by women living with HIV. But I think it's quite, it's an apt case that a lot of our national contexts could learn from. Another one is, of course, the Hungarian case, where that was decided by the CEDAW committee, where a woman had gone in for assistance with a miscarriage that she had. She was told that she's signing a form that has to do with her getting a C-section done, but instead there was like a note written by the doctor that said that she's consenting to essentially be sterilized, and she only found out at the end of that engagement. So I think an area of or a great area where we can litigate in a lot of the countries within the African context would be where there's failure in our countries to enact specific laws or policies and even regulations that provides procedural safeguard against forced sterilization. And I think this is also an issue that's coming up. I mean, it's been quite a number of years now since the rolling out in the Global South of the program on elimination of mother-to-child transmission of HIV, AIDS, and syphilis. And a lot of what's coming out in the reports that are coming out, especially from the African context, I think Zimbabwe has done a report, Uganda's done a report, and Botswana is currently working on a report. And one of the main human rights contentions is on forced, coerced sterilization, prolonged contraception, as well as abortion. And so there's quite, extensive documentation of that challenge, but there's not enough strategic litigation that's been engaged on. So I think that's quite a great opportunity that we could take as an emerging issue that we could look into. The second issue is, of course, access to medically assisted reproduction. So we're talking there about surrogacy, as well as assisted reproductive technology. So, your IVF, egg donation, genetic screening. And I think the JLN Kenyan case was a case on surrogacy. And it's an example of a case in which the court looked at the Constitution and engaged with the right to health, as well as other, provisions, and said that the state has an obligation to create a framework that essentially speaks to surrogacy. And that's a gap in a lot of the countries within our African region, is that either the legislation and policy and regulations are silent completely on the issue of ART, or when they speak to it, it's a lot more restrictive. And I think a final emerging issue would be the right to choose any method of contraception, so related to sexual health sexual health technology. In a lot of African states, I think there's great limitation, and not just African states broadly, right? But also in the communities that we work with as NGOs. There's a lot of limitation in what is offered to the women and adolescent girls who go to health facilities to access sexual and reproductive health rights. So, you know, areas of intervention then they appear in the manual are, of course, you know, access to other forms of or various forms of contraception. There are issues there that, you know, strategic litigation case can be crafted when it comes to the imposition of specific contraception on women and girls. So those are the three emerging issues and trends that I would say, you know, are quite critical for us to try and engage with.
Thank you, Lesego. That was very rich, and thank you for highlighting those new emerging trends. And I think part of the problem that we see when we talk about sexual and reproductive health rights, at least in you know, prior to reading this and, you know, being in the field, is that people are not often thinking about how wide the range of those rights is, right? People think, okay, maybe you're just talking about whether it's just, you know, the right to abortion or, you know, basic medical rights. But what was so amazing, what is amazing about actually Article 14 itself is how in depth it goes. And then this manual goes quite in detail. And I think, although it was very good, Lesego has just given us quite a teaser. I could have listened to it go on and on about some of these specific rights that are very, very unique in our cultural context. You know, if you talk about things like surrogacy, and these are things that we don't know about, and I'm very excited that there is a resource tool for litigators across the continent to be able to look and say, this is something that we can go to when these emerging topics are coming, because they are coming, and these are the lived realities of women across the continent. And a manual like this is going to empower them in understanding how to deal with this. And so I think my question for you then, Gladys, is, you know, the Dalai Lama Institute, it does a lot of work to popularize regional human rights standards. Now, the Article 14 has a lot of specific subsections in it. And in your experience, what are the standards that are under Article 14 that require elaboration that can actually be achieved through strategic litigation? Because Lesego has given us, you know, some of these emerging trends, but in your estimation, you know, when you look all the way from 14.1 to 14.2c, what are the particular sections that can be achieved in their fullness through strategic litigation?
Thank you, Nobu. The Dalai Lama Institute is involved in research as well as publication and teaching, both in South Africa and at the regional level. From this manual, reading through this manual, I would say that Article 14 sets, first of all, Maputo Protocol sets important standards on women's rights and sexual reproductive health in Africa. However, the effectiveness can only be established through enforcement within different domestic country contexts, where there's tangible reform in respecting, protecting, and fulfilling sexual reproductive health and rights of women and girls. Violations of sexual and reproductive health do not only give rise to violation under Article 14, but can also implicate other rights provided for under the Maputo Protocol, such as the right to be free from discrimination, the right to dignity, the right to life, integrity, and security of the person, as well as the right to be free from harmful practices and other forms of violations against women and girls. That's Article about 3, 4, 5. That's Article 2, 3, 4, 5 under the Maputo Protocol. Thank you.
Okay, thank you. And you touched, thank you for that, Gladys. And I'm glad you touched on the issues with litigating, this type of stuff at local courts? Because right now we're talking about this beautiful, wonderful regional document. And I think my next question is, I'm going to go back to you, Nerima, and say, how have you found litigating this type of work, some of the challenges at a national level? What comes up when you see moving the realization of this at a national level?
Okay, so I think, some of the challenges of litigating broadly with any of the standards set with a regional document or even an international document like CEDAW or the African Charter, the Maputo Protocol, is the requirements it does take for you to get there, to litigate it robustly at the regional or the international level. And then I think one of the key things is on admissibility, is that if you want to go to the African Commission on Human and People's Rights, you'd have to meet admissibility requirements, including exhausting domestic remedies. This then means you need to have been thinking through whether or not within your regional context, these rights have been catered for in a way that you can argue for them in your own national context now. And that's usually where we find more of the larger challenges, is that a lot of times states are going to sign on to these treaties, and they do all the time. They'll happily go and they'll sign on to the treaty, and then they'll also announce everywhere that they've signed on to the treaty. But domesticating the treaty is now where the problem is. And in some states that are not monist, so like Kenya is a monist state, for instance, which then means any treaty we sign becomes a part of our law. If you have a state that's not that's dualist, then it's not going to become a part of our law. And states are often very slow in adopting or domesticating these treaties. So from the perspective of many litigators within the country, the rights might not be available to interrogate at that level unless they understand the regional obligations and what that translates to. And that's usually the larger problem, is there's a limited understanding of what these obligations translate to in a national context. So once you sign the treaty, what does that mean? What are you supposed to do to actualize it? And many litigators don't necessarily appreciate that. So they may be very narrow in the scope of engagement in how they try to advance these rights. Another thing would be, we sometimes focus on a very narrow interpretation. So a good example would be, you can have with the Maputo Protocol, and I think the manual has done very well in unpacking the rights as per section. But if you look at Article 14.1b, which is your right to reproductive health, so the right to choose if and when to have children, the number and spacing of those children. There's also an article on the right to accessing family planning. There's an article on the right to reproductive health information. And then there's Article 14.2c on the right to access medical abortion. Now, you can focus on Article 14.2c by itself and now on an abortion question, but in reality, abortion by itself is a reproductive right. Being able to access one is a reproductive right. It's being able to choose that I do not want to have a child at this point, yet I'm pregnant. So we see that in the national context as well, in that with Kenya, for instance, you have Article 26 of our Constitution, which has the framing around access to an abortion, but we also have the guarantee to reproductive rights within the same Constitution. So a good starting point in understanding how to develop a right would be, what is the primary right you're seeking to achieve? But often people will focus on the narrow conceptualization of the abortion without grounding it on the broader right of reproductive health or reproductive rights, which then means questions of bodily autonomy are sometimes lost, questions on dignity are sometimes lost, questions of freedom are sometimes lost because the narrow conceptualizations might not allow you to get there. And I think that's where we've seen jurisprudence hasn't taken us as far as it could, because we narrowly conceptualize rights that then limits how then they're interpreted by the court.
Yes, thank you, Nerima. That is so good. Yeah, I think that's such a good point, and gives us so much to think about, how we narrowly conceptualize the rights. And we litigators struggle to approach the courts in a way that would end up with the rights being given meaningful realization, because these rights are cross-cutting, it's all intersectional. You don't just achieve one without the other. And as a litigator, as a strategic litigator, you must be able to look at it from all angles and be able to ensure that you don't just focus on one area, because that usually leads to, lack of advancement, which is what we've seen. And so to you, Lesego, I think one of the things that's very interesting is, when you talk about litigating at the regional courts and then going down to national, there's general challenges that people face: admissibility, jurisdiction, understanding how the system works, all the processes and procedures. But there's also, I think, an added layer of hardship when you're trying to litigate sexual and reproductive rights, at national level using regional instruments. And so in your experience, what are the challenges that you've seen that are associated with litigating, particularly in specific, your sexual and reproductive health rights at a national level?
Sure, thank you, Nobu. And I think Nerima, founded the response to that quite well. I think there are quite broad, challenges to litigating, just the strategic litigation in general. So you've got, of course, your socioeconomic and cultural challenges where, the costs of both time and money and the risks associated to whether winning the case or losing the case are great considerations for any client who would want to pursue a case. And there's also a lot of stigma associated with having a public case. So there's those clients-based challenges where a client would be reluctant to bring their case forward because of those compounded challenges. And then specifically getting into the Srhr challenges, you've got a lot of sexual and reproductive rights are either restricted or are criminalized, right? So, for example, there's vertical transmission of HIV and syphilis are criminalized in a lot of states within the African continent. The general approach towards abortion in a lot of our countries is criminalized. Sexuality in a lot of our countries is criminalized in general. So there are those those challenges which hinder a lot of women from, deciding to even approach a court on anything. Going back to just the HIV topic, 59% of adults who are HIV positive on our continent are women. And, of 4 adolescents who are HIV positive, 3 of them are girls. So there's a disproportionate way in which women are affected and impacted by the criminalization of transmission, whether it be partner to partner or it be vertical transmission from mother to child of HIV and syphilis and other STIs. So I think those affect, first of all, the client and their decision in approaching a court. And then a lot of our countries as well have not even ratified the Maputo Protocol. So for you to even bring it before the court is going to be, a challenge. You can't speak to it because it almost doesn't exist to the court.
That's good, Lesego. Thank you. I think these challenges are real, and thank you for articulating them well. So what Article 14 has so many specific sections that speak to so many rights, Gladys, and you've got the right to control one's fertility, the right to decide when to have children, the right to choose any method of contraception. There's so many specific rights that exist that are stated under Article 14. And so in your experience with the research and publication, which of these rights do you think that are the most key to be strategically litigated on the continent to bring the full realization of them?
Thank you, Nobu. Adding on to Lesego's point regarding ratification, if I may start from there, is that as of July 2020, out of the 55 member countries of the African Union, only 42 African countries had ratified the Maputo Protocol. And that despite the significant number of ratifications, the progress made in the implementation of rights of women in Africa has been quite slow and slow. So from my vintage point, as part of the research team, I'd say that firstly, by weighing in on specific and unique experiences of African women, such as protection from sexual transmitted infections, safe abortions, inheritance, widowhood, and harmful practices. Using strategic litigation as a benchmark can propel court action that highlight limitations of national legislation and advocate for change to enhance rights protected at the national level. Secondly, the Maputo Protocol is strategic to increasing access to justice and substantive equality for marginalized women and girls. And thirdly, that the intention is to inspire implementation of sexual and reproductive health and rights that address social and cultural rights that hinder the enjoyment of rights of women and girls. So from my vantage point, I'd say that is the value add of this manual, and especially focusing on these specific rights.
Thank you so much, Gladys. So Nerima, highlighting all these very specific rights, what would you say is your favorite provision under Article 14? And why is it your favorite, and what transformative power do you think that particular provision holds?
So if I had to narrow it down, I am a pro-abortion advocate consistently, but I wouldn't rely on Article 14 to say. I'd rather rely on Article 14(1)(b) as my favorite provision, because that therein lies the right to your reproductive rights. So which is fundamentally to choose. And how you choose is then prescribed in a number of different ways by the protocol itself. And it then allows states to, and it's very prescriptive. And this is what's always been good about the Maputo Protocol. It's prescriptive in that it doesn't allow for states to remain without doing anything under the guise of, well, we're not quite clear what we're supposed to do. So it's prescriptive in saying you must give information, you must provide medical abortion, you must do this, you must do that. But the right actually lies in Article 14(1)(b). And why it's my favorite is because with my country, for instance, we do have a reservation under Article 14(2)(c) of the Maputo Protocol, which is where you have the right to access a medical abortion. However, we don't have one under Article 14(1)(b). So under Article 14(2)(c) gives you one way in which you can access that right, which is actually through using a medical abortion, but the overarching right still remains. And while that remains, our state will still be obliged to find ways to allow you to access your reproductive rights. And if that then means that you have to think through whether or not I can do it through an abortion, that will be a debate and negotiation we would have to have. So I think fundamentally that's why it's one of my favorite rights. I do feel a slight criticism will be that while the article itself does mention sexual and reproductive health, it doesn't necessarily speak quite extensively to sexuality rights and sexual health quite as well as it could, but I do feel like the manual goes a step further into kind of defining what sexual rights are, what sexual health might be, and giving a working definition that might give us an extensive framework to understanding how we could use these provisions to creatively read in some of the rights that are not more explicit within the manual, within the Maputo Protocol itself.
Thank you, Nerima. That's actually also one of my favorite ones. I like the wording, right? The right to decide whether to have children, the number of children, the spacing of children. And it seems like such a simple thing to put on paper, but we know that so many women in Africa don't have that privilege or that opportunity to be able to make those choices. And so I think that's a very good choice. I'm gonna hop back over to you, Gladys. And so, but before I do, I'm just going to open up the floor, the internet floor, for our public participants to please ask any questions as we go through these questions. Please, if you have any questions for our panelists, please do not hesitate to ask. You can raise your hand and you will be unmuted. You can post your question in the chat box, or you can put it in the question and answer section. We are ready. This is meant to be a conversation for all of us to be able to learn and expand our knowledge base as activists and litigators on the continent for women's sexual and reproductive health rights. So whilst we're waiting for our questions to come, I'm going to come back to you, Gladys. What is the advocacy that is required in your estimation to support strategic litigation? And how can research institutes like the Dalai Lama Institute, contribute to this process?
Thank you, Noble. I'd say value is created when individuals, human rights defenders, lawyers and researchers, as well as policymakers, absorb new knowledge and add it to existing knowledge. And as such, I'd say that the manual is a very rich document with various objectives, and that acknowledges African women and girls are neither monolithic or homogeneous, and therefore any litigation efforts must consider the multiple differences and intersecting identities as well experiences of African women and girls. So to support strategic litigation by way of research institutes such as the Dalai Lama Institute are compelled to reflect on contextual differences within different countries and contexts in Africa, as well as the multiplicity of different intersectional factors that exacerbate rights violation for different women and girls. Research also may encompass clarifying the scope of the obligation of the state to provide accessible, affordable, and quality medically assisted reproductive services. Well, in other words, what I'm trying to say is that to ensure integrity of information, research as an advocacy tool to support strategic litigation on sexual and reproductive health and rights requires a modified approach that is reflective on the lived realities of women and girls in Africa. I'd say that is the main role of research institutions such as Dalai Lama Institute.
Thank you so much, Gladys. And so our questions from our participants have started coming in. So please, if you have a question, do not be shy. There are no wrong questions. There are no not clever questions. This is a safe space and we all want to leave with the knowledge that we came for. So the first question, I'm going to direct it to you, Lesego. The question is, what is the best way to use strategic litigation to challenge the criminalization of abortion and criminalization of HIV transfer?
Thank you very much, Nobu. I think the best way to use strategic litigation to challenge the criminalization of abortion and HIV transfer, be it vertical or partner to partner, would be, of course, thinking around a strategy that, first of all, of course, has social impact and protects the client in such a way that the client themselves will not be exposed to, the effects of criminalization. So, thinking around the case in such a way that once the client has filed their matter, if the matter, goes downhill, they're not going to face the crackdown of the law. They're not going to find themselves imprisoned. And that's going to take a lot of working with, like I was saying, local NGOs, international organizations or regional organizations, as well as possibly working with national stakeholders to see how the client would be protected, first of all. The second thing is specifically thinking about abortion. One of the things that goes along with abortion in a lot of our countries is the justifiable limitation that can be invoked by healthcare providers who, for example, don't want to carry out the process of an abortion. And so the thinking around that would be, what alternatives are there? How can we get the court to make decisions that, not just, of course, force the the person carrying out or not wanting to carry out the abortion to do it, but also, you know, open up options to women internally to be able to access abortion.
Thanks, Lesotho. Just to answer a quick question by
So it looks like we have lost Nobu. We've got a few more questions. We've got a question from Dr. Stella, who says, like Narima has mentioned, how do we get to address SRHR needs for non-binary women who have multiple level of barriers, from being criminalized based on their sexuality to facing stigma and discrimination when accessing their healthcare needs? We need to also speak of how problematic the health and the health system are, or the health system is to binary and ableistic, as this is exclusionary. So Narima, I'll ask you to answer that question, and I'll direct the third question that we have from Matapelo to you, Gladys. I'll just read it out. It says, this is really important knowledge that I know people need to be educated about. How are you guys educating people about this topic or sharing more, if not already?
Thanks, Leseho, and thanks, Dr. Basir, for that question, and I'm glad to see you here. So I think the starting point is, I think you have already said it in your question itself. The health systems, the legal systems are not cognizant of inclusivity of varying people. And often it's very heteronormative in the context of understanding how humans are. So non-binary women are often left out. And I think a starting point in addressing it is research. I've always had this in HIV circles. While they're very clear on the interaction between HIV and men who have sex with men or gay men, it's not as clear with lesbians. And it's consistently not as clear, but then there's also not enough research to dispel the fact that there might be some effects. And that's the reality, in that while we might understand how women in heteronormative contexts are disproportionately affected by HIV, we would need more research to understand how non-binary persons are affected by HIV. And this is true for all SRHR questions, because it's not enough to conduct research in one specific context or the one population. And Gladys spoke to this by saying, women are not a monolith. We have transgender men who may have been biologically female, who might have reproductive health needs and challenges that might fall within the Maputo Protocol. And it's very difficult to pull out the experiences if we don't have enough research around that. The next thing will be really on being able to read into these rights and allowing us to use litigation to contextualize our reading in. So a consistent theme across this should be non-discrimination. The Maputo Protocol is brought about by the reality that discrimination uniquely affects women. It comes out of Article 18 of the African Charter, which requires that the Union develop a protocol to address discrimination against women. And now non-discrimination has to be looked at as against women compared to men, which is a huge issue, but also within women as amongst themselves, because that is an issue that needs to be considered. And in reading through what non-discrimination can look like, we can use litigation to then try to evolve some of these rights to consider how women are in their different manifestations and how women would manifest, and then cater for that. Quite honestly, it wouldn't be easy reading the protocol as is to think of a lesbian woman or a transgender man or a transgender woman within this protocol. But using the non-discrimination clause with access to a lot of things, including health services, education, we can find ways to argue that these populations are catered for within this protocol if it was read creatively. And we've seen courts do this in the past. It's just how we use this as a litigator's tool to pull out some of those questions.
Thanks, Nerima.
Thank you. Thank you, Nobune. Thank you, Lesego and Nerima. So the question directed to me was, how do we share information and educate people on using this manual? First of all, I wanted to mention that we've shared this manual on the chat box that everyone can download and have a look at. And secondly, that this is a rich document that is intended to be used by a wide array of people, lawyers, human rights defenders, civil society representatives. And the language that is used is easy to understand as well as to follow, but there's also a lot of a wide range of information in the sense that it's just not only about Africa. Yes, it is focused on Africa, but we borrow good practices from other parts of the world. And as such, it's rich and it's technical in that it supports human rights litigation. It's intended to support human rights litigation, but also for knowledge, anyone using it. Once we share the document, we intend to engage with it. So when going through litigation, we intend to highlight that there is a manual that can be used to elaborate on Article 14 of the Maputo Protocol. We also intend to, apart from having it as a document, these sessions, these webinars and discussions on it also are a helpful way to educate people about the manual and what is contained in it. Thank you. I hope that's sufficient, Matapelo.
Thank you, Gladys. I think it is. I think later on, Lesego will also give us a little bit more detail on how, how ISLA does assist this type of work. And so thank you for that. And there is more information coming for people as the chat goes. Quick apologies, I got cut off. My Wi-Fi and our electricity of our internet world that we live in. So the next question here is from an anonymous, and the question is for you, Lesego. And the question is, how can strategic litigation be used effectively to ensure states take all appropriate measures under Article 14.2, particularly where effective implementation of Article 14.2 could impact the realization of the substantive rights under Article 14.1? How can these two provisions be most effectively reconciled to provide maximum protection? I'm going to give that question to you, Lesego, but it also speaks to what Nerima had spoken about earlier. So if you have anything to add, Nerima, please feel free after Lesego has answered.
May I have a moment to think about it and then get back to it, Nobu?
Okay, sure, that's perfectly fine. I'm going to pass on the next question to you, Nerima. And the question is, how can we engage faith-based organizations like the Catholic Church on issues like this? Because we know how incredibly contentious sexual and reproductive health rights are. So I'm just going to extend that question to not just talk about faith-based organizations, but to also include cultural spaces. You know, in a lot of African countries, and here in South Africa, we have strong traditional leadership, you know, that is still over 16 million or something like that. South Africans are under that type of traditional authority, and I'm sure the numbers are the same across the continent. So how do we engage on these Very
Nobu.
liberal. It's interesting.
Oh yeah, thanks, Nobu. I mean, one thing, let me start with traditional leaders. One thing is that it might not be as liberal or novel as is assumed, because we can pick up some cultural practices that speak to some of the rights we have here. So for instance, like surrogacy as a thing, as it's conceptualized within as surrogacy is a part of some African cultures that comes from woman-to-woman marriages. And in those cultures, you're actually allowed to, as a woman, marry another woman for purposes, a number of different purposes, including bearing children on your behalf. And this can sometimes be utilized if you're unable to bear children by yourself. And I've actually seen it even in my family, where one of my grandfather actually had 3 wives. The first couldn't have children, and then she brought her sister as her wife to then bear their children in that home. And then the children belonged to her, my first grandmother, and not necessarily broadly speaking. So that is a conceptualization of surrogacy that can be pulled from. Similarly, we have abortions that existed prior to medical abortion being introduced, and in ways using herbs and certain medicines, and this was understood by many women. So it's one, you can actually tap into cultural practices that understand this and understand these cultures and try to use them in a way that's protective towards women. And one of the key things that you can do with cultural practices is find a way to focus on what's protective towards women and try to include them within the spaces of those decisions. Often the decisions are taken in male spaces. So how do you expand the spaces to include women in those spaces? And Kellen does some work around this. We work with Cultural Structures Project, because a key thing that has been noted within the Maputo Protocol and not this manual is the rights of widows. And we work very extensively with widows, but a way that we can work with them, and we have in the past, is working with elders and structural programs within elders who take decisions on their behalf to ensure that they understand the nature of their decision making and make sure that they're more inclusive. But in terms of now dealing broadly with religion, culture, and how they interact, I would say something like the Catholic Church or any religious faith-based organization that can have a lot of extensive power. And I would also again point out to the manual, because there is a part that discusses fetal rights, and then the work around fetal rights by anti-abortion movements within South Africa and other countries, and how the constitutions have been used to address these questions. And we also have movements around like Catholics for Choice, who do understand. Now, while religion does exist, it doesn't exist in a vacuum. And an important thing has been in terms of the messaging is freedom of religion and from religion. Would be the idea that you do not force religion upon other people, but we appreciate that you have a religion that you want to exercise, and you can by yourself, and that's fine. And no one can ever complain about that, as long as you're taking a decision for yourself, but not to extend that beyond the self, to try and push for policy that's restrictive, that's not cognizant of women's rights. And that's a huge question that we have consistently. And when you work with faith-based organizations, it's to have entry points, for me at least, that are palatable to them, and try to build relationships from those entry points. Like HIV has been a good entry point, but we have to be cognizant that it wasn't always. For a long time, the church was as much of a barrier to HIV treatment programs as the state was. And only in getting them along the ride into being part of it are we seeing changes in HIV. And we need to have the same attitude with this as well, in that we do need them to be part of the ride, because they do control a large part of the population in terms of the schools, the politics, the policymakers, they do. But how do we get them as vested in women's rights as we are, and what is our good entry point? Adolescent girls, young women have always been a good entry point, and it's a way that you can go in terms of ensuring that you can protect the rights of these people, utilizing the church as a framework. You can start with abstinence, but then you can move it across the board to information, protection from harm. And these are some of the programs that we have, but it is very contentious. And I think just go to the manual where you do have to go to court, where you do have to litigate on this. The argument is always people have to be free from religion and have to choose when to practice a religion and when not. And this can't be prescribed across the board, especially since most of the countries within this continent, at least sub-Saharan Africa, are not religious states.
Thank you, Narima. Thank you. That was a good answer. And I think what I like about what you said is the importance of bringing people along with us, you know, because sometimes there is a general sense off the bat that, you know, faith-based organizations or the traditionalists, they're going to be against us or they're anti-us. But one, bringing people along with us is important. And secondly, a point that we often forget that I'm so glad that you highlighted, so I'll repeat in case anybody missed it, is that a lot of these institutions, whether it's traditional or religious, within themselves contain protective measures for women. And so the idea is, how do we expand on that to make it more inclusive and effective? And so thank you for that, Nerima. I'm gonna circle back to you, Lesego, before I ask the next round of questions.
Sure, thank you so much, Nobu, and thank you so much for your patience, Anonymous. So I think it's really about using strategic litigation to keep clarifying the scope and content of rights. So using strategic litigation to clarify evolving standards and to keep broadening the scope of the protections and ensuring that those who are unseen by the law, you know, get some sort of meaning and appropriate, and that appropriate measures can be clarified through the strategic litigation. So you know, we know that under socioeconomic rights, states have an obligation to progressively realize you know, persons' socioeconomic rights. So it's about challenging the retrogressive measures.
Okay, thank you, Lesego. The next question that I'm going to ask is from Mandy Maderiko, and I'm just going to leave it open between any of the speakers who would like to answer, Lesego, Nerima, or Gladys. And the question is actually about, it says, in litigating Article 14 rights and generally, how do we navigate and overcome the fact that judges tasked with making decisions that are transformative are members of the society who may themselves carry, advocate, or believe some of the prejudices and stigma that limits diversity, choice, and inclusion? Nerima, would you like to have a go at it? I think it's an excellent question about just the human condition of, sometimes we all carry biases, including those who are our judges. And how do you overcome, how do you progress? Because obviously human beings have progressed over time with these types of issues.
Mm-hmm. No, thanks for that. And I mean, I would say not sometimes, all the time, we always carry biases. So it's a full-time job checking your bias, and not everyone does that. And that's true for judges, and without as much scrutiny as many of us would have, in that a lot of the time judicial wisdom is normally thought to be both objective, impartial, and removed from almost a human being that exists in a society. So whatever biases you're seeing are likely to exist within your judicial officers and are likely to be shown in the judgments. And what I would say is, depending on the issue, it's really important, one, depending on what you want from a case, to know if you have the right facts on the right day before the right bench. So right facts on the right day before the right bench. And it's always important to think about that, because you might have a long-term loss that might not be worth interrogating at that point, and you might want for that to change. And the bench does change, and judges do change. So just being able to map out who exists at that time. I think a good example would be the Repeal 162 case in Kenya, which was really around same-sex, criminalization of same-sex sex. And like, a number of things came out of it, but the key thing was, it wasn't the right bench for the discussion. And then it not being the right bench had much was much more punitive than was necessary, because a dismissal would have been sufficient if they didn't feel like the case met the facts, but they went far enough as to almost close it for future discussion as to whether or not we can interrogate criminalization of same-sex sex. So that's really what we wanted to consider, is whether or not we can ever interrogate it, and they almost closed that door. So being able to think that through, and it's an expensive journey when you have to consider it, which is why you have other options available to you, like advocacy, like lobbying, like community mobilization and awareness. And I think litigation does also offer a lot of solutions, but it's certainly not a silver bullet. So there will be biases, there will be things in place that you can't always overcome, but being able to find that if you have the right facts, you have an easier way to map your bench and get a sense of whether or not, with the bench available, you're likely to win, or even if you're likely to lose, would it be a bad enough loss that closes the door for a rights discourse for a long enough period of time that it's not worth engaging in altogether at that time?
Okay, yeah, I think that's true. And thank you so much, Neriman. And I think, you know, in understanding that judges do have prejudices, there is work that ISLA has done in engaging judges and in making sure that manuals like this accessible decisions, and so that they are, as we are all learning, that they're all a part of the process and the journey with us, so that, you know, when you talk about feminist litigation methods, it's not just the litigators themselves that should be alert to this, but it should be those who sit on the bench as well and are learning. And I'm excited that even with the progression of time, you know, you see more judges attending workshops, you see more judges going for trainings so that they can gain a deeper understanding. And when cases appear before them on the bench, they're not just, you know, completely lost, like, oh, what is actually happening here? So we're going to take one more round of questions. For anyone who has any questions that they'd like to ask, please go ahead. Lesego, I'm going to ask you, you know, so you head up the unit at ISLA, and to those who are participating and are wondering, how does ISLA work with people who have cases around sexual and reproductive health rights? And what are the different kinds of legal services that ISLA does provide in these situations?
Sure, thank you, Nobu. But just point of correction, I don't head up the unit. I am the thematic lawyer in women's socioeconomic rights thematic area. So ISLA uses strategic litigation for social impact. And how we do that is that our model is rooted in working with movements within countries. So, you know, our vision is that a case is not a case in isolation. It's a case beyond just the courtroom win or a courtroom loss. And so we work primarily with who we call network lawyers, lawyers across the region who we work with for a period of 3 years at a time. As feminist network lawyers, they're trained under different institutes, the Women's Socioeconomic Rights Institute and the Violence Against Women Institutes, and they engage with cases throughout the period that they are our network lawyers. And how we work with our network lawyers is that we work either as amicus or as advisors to counsel or as legal representatives. So as amicus, I think, you know, most people who are the participants in this discussion would know, but I'll just elaborate for those who might not know. Essentially, when there's a matter before court that is of interest in any of the thematic areas that ISLA is looking into or working on, and if a case has already been filed and we are not necessarily involved with any of the litigants, but we think that there's a point of value that we can bring into the case itself, we could then work towards the development of an amicus brief outlining, you know, the specific point or specific points of intervention that we offer. One of ISLA's strengths is in comparative analysis. So in every brief that comes out of ISLA, you know, under amicus, it will have that comparative analysis. And then we also work as advisors to counsel where there's a matter or there's a case that is brewing, has not yet gone to court, or one of our network lawyers is thinking about the development of a case under one of the thematic areas, they present it to our litigation committee, and we think around the theory of the case, we think around what the objectives of the case are, what the broader impact of the case would be, try to develop an advocacy plan in which we work with other partners within the countries, within the country rather, where the case emanates from. And we are behind the scenes essentially as advisors to counsel. We do research work for the lawyers, or we work with them to do research on the cases. We work on the pleadings with the lawyers, or we review the pleadings that they would have drafted. And then we also work as representatives in certain countries where we have certificates to practice in. We also, outside of the network, work with what we call collaborative partners. So we've got countries where we don't have network lawyers, but we work, for example, in Sierra Leone, we're currently pursuing 2 matters where we don't have a network partner within the country. So what we do is that we source an NGO, an organization, or a law firm that has similar values to Isla's, that does feminist litigation, and we work with them towards the development of either an amicus brief or the pleadings if we're working as advisors to counsel. So that's how Isla works.
Thank you for that very detailed breakdown, Lesego. I think that the Isla model is absolutely unique, and it is such an exciting organization to exist at such a time as this on the continent, advocating and ensuring that there is collaboration across the continent that works to see the fulfillment of the broad range of women's rights. And I'm so glad that everybody was able to attend and be a part of it with us today. I'm going to ask our panel of experts to just share with us any parting words or last thoughts just before we wind down and close. Gladys?
Thank you, Nobu, and thank you, colleagues, Lesego and Nerima, for this session today. It was quite informative, and I do appreciate that the participants were able to engage. From my parting shot is that strategic litigation on sexual and reproductive health and rights has a positive impact because it extends much further than the individual, with the outcomes also affecting family, community, and society as a whole. And as such, we should consider it as a very powerful advocacy tool going forward, especially when it comes to women and girls in Africa. Thank you.
Thank you, Gladys. Nerima?
Thank you so much, Nobu. And I think parting shot is to congratulate Isla on the launch of this manual. It's a brilliant manual, and to ask everyone to read it. It's so useful. The interaction between regional systems with international systems, looking at cases from different jurisdictions and trying to weave into an understanding of rights is really what we really try to capture in law school, but can't always, and what we really hope to do as litigators. So it's a very useful manual. Please read it, please rely on it, and let's really work together towards really bolstering the jurisprudence on SRHR within the continent.
Thank you, Nerima. Lesego?
Thank you so much, Nobu. Thank you, Gladys. Thank you, Nerima, and thank you everybody who joined us for this discussion this afternoon or this morning, this day. I think, like Nerima was saying, the manual is quite an important resource, and it's been shared quite a few times on the chat. Please download it, and please feel free to reach out to us at ISLA if you've got any thoughts on the possible cases that emanate from the different countries that you're all from. We look forward to working with you.
Thank you, Lesego. And so this series of publication launches that have been going on have been done in collaboration with African Feminism. And African feminism has been absolutely amazing. And one of the great things that they have done in this partnership is have young female bloggers, young feminist bloggers, write our blog about each publication as it is coming out. And so I just want to hand over for a few minutes to Anne Linda Namadu, who wrote this week's publication, and it reads really well. So I encourage you all to please go and read it. It will tantalize your taste buds to go and read the entire publication. I think she summarized and highlighted the great points accurately. I'm going to hand over to you, Anne.
Thank you, Nobukosi. I enjoyed working on the publication. As someone who is not from the legal field, I was enlightened that there was, first of all, such a thing as the Maputo Protocol, and secondly, that there is an effort towards ensuring that it doesn't just sit as a document, but it becomes active in legal procedures. And what I liked most about it was the fact that it was cognizant of the contextual differences, and it kept on encouraging also litigators to be cognizant of these facts. So overall, I felt enlightened about the manual, about the protocol, and I feel that from now on, as a writer myself, is going to be something, it has enlightened me about Srhr work, and it will be part of my conversations, because it was actually quite easy to understand, which was surprising for me as someone who, I guess, is out of the field of law. Yes, so I thank African feminism for the opportunity to work on it.
Thank you, Anne. It is a really good blog post. So if you want to access the post that Anne has written, please visit our social media pages as well as African Feminism's ones. You will see them. We are on Twitter, we are on Facebook, and the invitation that you got when you logged in has all our handles for you to access this. Once again, thank you so much for joining us today. Please do download the publication. It is available in the chat box, and it will be available online through all our social media pages. We are ISLA at the very core of the work that we do. We are collaborative in our nature. And just to echo what Lesego said, if you have any ideas or that you'd want to partner with ISLA, if you have cases, if you are looking for more of our publications and manuals, please do not hesitate to contact us. After this conversation, you will receive certain links and information on how to be able to contact ISLA. Please do not hesitate. We want to collaborate with you. We want to partner with you in bringing a realization to the fullness of all these beautiful rights for women across the continent. Once again, thank you for joining us. We look forward to seeing you in 2 weeks. So keep your diaries open, and yeah, enjoy the rest of your day and have a wonderful weekend. Thank you.
Thanks, Nobu.